Hello everybody, this is Dr. Cole, Sunday night, December 6th, as we enter exam week, week 16 for Con Law, Political Science 3753 for the fall term. Everyone, let me take a few minutes here, try to get ready for this week. I am a little concerned about people's term papers. I have communicated with a couple of students about term papers, I think. Everyone, please realize, according to the syllabus, everyone is required to turn in a term paper. We're getting a little late. I'd be happy to communicate with anyone by email. Everyone should have gotten by email a list of cases, Supreme Court cases, that can be the basis for your term paper. And I also tried to repeat an announcement from earlier in the term about how you can research that. But please do not forget about that. Grades are due next week, Tuesday the 15th at noon. I need to have the papers by Saturday if at all possible. If you have to wait until Sunday or Monday the 13th or 14th to get it in, I should be able to look at it. But preferably we would like to have them by Saturday the 12th. Okay. And remember, it is on the syllabus as a course requirement. So you should plan on turning in a paper. It's getting a bit late if you haven't gotten started on it, but you do need to turn something in, and I'd be happy to communicate with you about it. We've tried on a couple of occasions to get out the list of topics. Again, take a Supreme Court case or a couple of related cases as your topic. Okay. And we've tried to get some advice out about how to research this term paper project. Now everybody, the exam is going to be available for 72 hours instead of 48. I'm going to extend it through Friday. So we'll have Wednesday, Thursday, and Friday, the 9th, 10th, and 11th, to take the exam. We will chat online Tuesday evening for 45 minutes at 7:45 to 8:30. Okay. I'm chatting with all my classes Tuesday night, so we'll do a little later than our regular time of 7. We'll begin at 7:45 and go until 8:30 to chat before the final exam. Now everybody, a good many people struggled on the midterm. You have a little bit more material for the final. The class notes for lectures 13 through 27, plus expect 10 or 12 items to be repeated off of quizzes quizzes 5, 6, 7, and 8, not 4. The last 4 of 8 quizzes, quizzes 5, 6, 7, and 8. Okay? Expect about 10 or 12 of those to be repeated. So if you look at that material that you had to read for those 4 quizzes, that's about a quarter of your exam. Now, let me take just a few minutes to run through some of this material. Now, there's 15 sets of class notes. Basically, there are 7 topics. Okay? Right to privacy, due process, search and seizure, freedom of speech, freedom of the press, freedom of religion, and then equal protection, which is largely about racial discrimination. You'll notice there's 3 sets of notes about that at the very end of the term. Class notes for lectures 25, 26, and 27 on 14th Amendment issues, equal protection, which mainly involves racial discrimination. Very quickly, okay, looking at lectures 13 and 14 on the right to privacy. Of course, you need to be familiar with Roe versus Wade, but before that, there was the contraception case, Griswold versus Connecticut, where the right to privacy idea, the idea that the Constitution implies a right to privacy, was proclaimed for the first time. So Griswold versus Connecticut, Roe versus Wade. Then after Roe versus Wade, the most important abortion case is the 1992 case of Planned Parenthood versus Casey. Planned Parenthood of Southeastern Pennsylvania versus Casey. Okay. That's the case in which Roe versus Wade was reconsidered. It was expected that Roe versus Wade might be overturned, but it was not. The Supreme Court did change its doctrine about abortion somewhat in Planned Parenthood versus Casey. Then we have the partial birth abortion cases. Okay. which both involve a gentleman named Carhart, who performed abortions, Stenberg versus Carhart, 2000, and Gonzalez versus Carhart, 2007. Now, in the first of those, the court struck down a state limitation on so-called partial birth abortions at the very end of a pregnancy. After that, in 2003, a federal partial birth abortion ban act was passed. And then there were some changes on the court. The court upheld that federal prohibition on so-called partial birth abortion in 2007, Gonzalez versus Carhart. Now, some right to privacy is largely about abortion. That's the big controversy in the political system. Cases involving homosexual behavior, gay rights, if you will. Be familiar with Lawrence versus Texas, 2003, involving sodomy laws, and of course the same-sex marriage case, Obergefell versus Hodges, 2015. You'll also want to look at the very end of Lecture 14 and Judge Robert Bork's views on these issues, which may have contributed to his not being confirmed as a Supreme Court justice. All right. Due process. Okay. Now, there was a series of cases from the 60s to the 90s, the 60s to the 90s, on discrimination in jury selection. The court moved in the direction of opposing racial discrimination in jury selection, where a prosecutor might seek an all-white jury for a black defendant, perhaps. Okay. Also be aware of such cases as Gideon versus Wainwright and Miranda versus Arizona from the 1960s. Okay. Gideon versus Wainwright, it was ruled that the right against self-incrimination implied a right to legal counsel in a criminal case. And of course, that was a case that was brought by an indigent named Gideon and made it all the way to the Supreme Court. Gideon versus Wainwright, 1963. And then, of course, Miranda versus Arizona is the one that we're all familiar with from police procedural shows, the one that mandates that a defendant be read his or her rights before being interrogated in police custody. Also be aware of the capital punishment issue. Okay. There were two decisions in the 1970s. Okay. In the first one, the Supreme Court appeared to have declared capital punishment unconstitutional. But 4 years later, it came back in the case of Gregg versus Georgia. Both these cases were from the state of Georgia. And in Gregg versus Georgia, okay, the Supreme Court says it will permit capital punishment under certain conditions, one of which is that the verdict and the sentencing have to be separate procedures on part of the jury. All right, search and seizure. Everybody, you need to be aware of exceptions to the warrant requirement. This will be especially important for some of you in law enforcement. Most important are the hot pursuit doctrine, the exceptions that have been made for automobile searches. Okay. You can almost never search a home without a warrant, unless you are in hot pursuit of a suspect. But the automobile being portable has been treated differently. Now, you'll also want to be aware of the 1968 decision in Terry versus Ohio. Terry versus Ohio was the case that allowed stop and frisk policies, because the Supreme Court said it would allow a standard of reasonable suspicion rather than probable cause, or reasonable suspicion would suffice for probable cause. That, of course, is highly controversial, especially recently, because it leads to what many people feel is a policy of racial profiling in deciding which suspects will be stopped out on the street. Right. Electronic eavesdropping and privacy with regard to electronic communications in general is a very sensitive issue. It's expected to be more and more sensitive going forward as more and more business is conducted online. One important decision was in 1967, Katz versus United States, when the Supreme Court decided it would treat a wiretap as a search and seizure for which a warrant was required. Also be aware of the controversy surrounding the Patriot Act, going back to the aftermath of 9/11/01. Carpenter versus U.S. 2018 was a case in which, to oversimplify, the Supreme Court decided it would treat cell phone records as something like a wiretap. In other words, a warrant would be required to search cell phone records. And on the basis of that, a conviction was thrown out in the case of Carpenter versus U.S. The exclusionary rule, okay, the law, the rule that says that evidence unconstitutionally obtained cannot be admitted in court. The court considered that in 1949, Wolf versus Colorado, but did not proclaim that as a rule until 1961, Mapp versus Ohio. But everybody, in the meantime, since Mapp versus Ohio, a loophole has been carved out to the exclusionary rule that some people say is big enough to drive a truck through. In United States versus Leon in 1984, they tried to say that if the authorities were acting in good faith, even if there was something wrong with the search warrant, the evidence could be admitted. And many people think that that effectively neutralizes Mapp versus Ohio. But be aware of the cases surrounding the exclusionary rule. Okay. Freedom of speech. Okay. The clear and present danger standard was laid down in Schenck versus United States that goes all the way back to the World War I period. It was decided in 1919. Okay. In Gitlow versus New York, 1925, they laid down the bad tendency standard, which is a less friendly standard to speech than clear and present danger. But in Gitlow versus New York, they did incorporate the First Amendment and its free speech guarantees against the state governments. Okay. The communist cases, everybody, over the passage of time, they have become more friendly to radical or even communist speech. In Dennis versus United States, which is right at the beginning of the Cold War, 1951, they were unfriendly to a speaker in that position, a radical left-wing speaker. They've become more friendly to radical or even communist speech over the passage of time. Okay. Fighting words. Okay. This came up in the case of RAV versus St. Paul. Fighting words was a doctrine of long standing. But in RAV versus St. Paul, they threw out a St. Paul, Minnesota hate speech statute for going too far, basically. Okay. But symbolic speech has been recognized. In the Des Moines School District case, Tinker versus Des Moines, that involved an anti-Vietnam War gesture by students in the Des Moines School District. And then Texas versus Johnson was the flag burning case from 1989. Also be aware, everybody, of the issues surrounding the Citizens United case in the year 2010, when they used the First Amendment free speech guarantees to strike down certain campaign finance regulations, so-called independent expenditures especially. All right? Freedom of the press. Be aware of the trial of John Peter Zenger going all the way back to 1735. In which a precedent was laid down, and it became established that seditious libel, prosecutions for seditious libel would not be possible in the United States. Truth will always be a defense in free speech cases in the United States. Okay. Know the Stanford Daily case. In the Stanford Daily case, a search was conducted of the newsroom of the Stanford University student newspaper, the Stanford Daily. The Supreme Court upheld that, but Congress subsequently came back and said that in such a situation you need to get a subpoena of the newsroom rather than conducting a search. Subpoena the evidence from the proprietors of the newspaper. The Pentagon Papers case involved thousands of pages about the history of the Vietnam War in the bowels of the Defense Department. This was one of the most difficult cases we ever had on the matter of prior restraint. And the Supreme Court held that the New York Times and Washington Post could not be restrained in advance from publishing stories based on the Pentagon Papers. Now, libel, everyone in libel, if you are a public figure, you have to prove actual malice to collect a libel judgment. This means you have to show that either the statement was false or was made with reckless disregard of whether or not it was true. Okay. Now, they tried to extend that even to private individuals where the matter at hand was one of public concern in the Rosenblum versus Metro Media case, 1971, but then they back away from that 3 years later in Gertz versus Robert Welch Incorporated, 1974. Obscenity, okay, the binding precedent is the Miller case, Miller versus California, 1973, where they lay down 3 criteria for whether something can be prohibited as obscene. And it's an area of law where the Supreme Court has been much criticized. They are much stricter and much more willing to allow exceptions or restrictions on child pornography than on pornography in general. Okay. Religious freedom. Okay. Our discussion begins with the Virginia statute for establishing religious freedom, going back to the year 1786, written by Thomas Jefferson. This is a fairly separationist doctrine. Okay. On the whole, our First Amendment constitutional law on freedom of religion has been pretty separationist, raising a wall of separation between church and state, although that language is not in the Constitution. Keep in mind, everybody, there are 2 provisions in the Constitution about religious freedom: the Free Exercise Clause and the Establishment Clause. Okay, now, one of the more important cases on free exercise was West Virginia versus Barnett, 1943, where they decided that the Jehovah's Witnesses or their children could not be compelled to say the Pledge of Allegiance at the beginning of the school day. That would violate their free exercise rights. So they regarded that as an illicit act of worship of the flag. Okay? Now, everybody, an important case regarding the Establishment Clause and also free exercise was Employment Division versus Smith, 1990. Justice Scalia wrote this decision. He said that in this particular case, which involves some people who wanted to smoke peyote as part of a religious ceremony and then were denied unemployment compensation after they were fired, Scalia said that on the whole he was wary of religious-based exceptions to generally applicable law. Okay. He found against the peyote smokers in Employment Division versus Smith in 1990. Nevertheless, everybody, we often have made exceptions to general laws for religious reasons, for free exercise reasons. Some examples include Wisconsin versus Yoder, where the Amish people wanted an exception to the compulsory education laws by the time their kids got to high school age. The Supreme Court found for the Amish. More recently, involving the Obamacare regulations that required employers to provide contraceptive coverage, well, in the Hobby Lobby and Little Sisters of the Poor cases, those employers were given exceptions to that requirement on free exercise grounds. They objected to providing their employees contraceptive products and devices on religious grounds. Masterpiece Cake Shop was a relatively narrowly decided case, which they held that a baker could not be compelled to decorate a wedding cake for a same-sex couple. But you'll notice the way that decision was written, it may very well come back to the Supreme Court, the similar issue. Okay. Now, Lecture 24, everybody, there have been many cases, and it's sort of a sore spot in constitutional law, the treatment of religion in public schools. Okay. Now, it's a sore spot for a lot of parents who would like to give their children their religious education along with their general education. But under the separationist interpretation of the First Amendment, that's not allowed to do that. You have to pay tuition to a private religious school, and that's kind of a sore spot in American politics. Okay. Everybody, Lemon versus Kurtzman, 1971, lays down some general principles for the relation between church and state in the United States. And the main thing you find in that decision is no excessive entanglement between church and state. There are a couple of criteria laid down, but that's the main one in Lemon versus Kurtzman, 1971. No excessive entanglement. Everyone also be familiar with Board of Education versus Allen, 1968. That's one in which they upheld a textbook loan program on the basis that the loan of textbooks to students in private schools was of benefit to the student, not the school. Okay. They have permitted state governments to provide textbooks to students in private and parochial schools on the basis of the child benefit theory. Okay. Now, Zellman versus Simmons-Harris, 2002. The Supreme Court agreed to permit a limited experiment with a so-called voucher plan, where a parent would receive a tuition voucher and could use that voucher to send the child to a range of different schools, public or private. Okay. The big school prayer case is Engel versus Vitale, 1962. Okay. No prayer in school, at least not a prayer written by the school authorities. And then there were a number of cases in the 1980s and 90s where various states try to get around that, but the court generally does not permit it. Okay, everybody, racial discrimination. Lecture 25 takes you through from slavery all the way through the Brown versus Board of Education decision. The 14th Amendment was added to the Constitution, attempting to provide equal protection of the laws to everyone, giving people a cause of action in some cases against their state governments. Nevertheless, the Supreme Court in 1896 upheld the separate but equal doctrine in Plessy versus Ferguson, only to strike that down in 1954, Brown versus the Board of Education. Be aware of both of the Brown cases. There was a follow-up to the first Brown case in 1955 after the original decision came down in 1954. Subsequently, be aware of the history of the Little Rock school desegregation crisis, the subsequent Civil Rights Acts, especially the one in 1964, the Supreme Court cases involving the Charlotte, North Carolina School Board, and also the one from Detroit, Milliken versus Bradley, 1974, in which the Supreme Court signaled the limits of how far it was willing to go with school desegregation. Now, with regard to the public accommodations provisions of the Civil Rights Act of 1964, be aware of the Heart of Atlanta case and the Katzenbach versus McClellan case. In those cases, the Supreme Court upholds the Civil Rights Act and allows its applicability to the desegregation of facilities such as hotels, motels, and restaurants, public accommodations. Then, last of all, the class notes for Lecture 27 deal with discrimination in employment and education, including the issue of affirmative action. Be aware of Griggs versus Duke Power, 1971, in which the Supreme Court says that if a test for employment is discriminatory in effect, you have to show that that is job-related or it'll be thrown out. And then when the Supreme Court went back on that standard, Congress reinstituted it with the Civil Rights Act of 1991. The big affirmative action decision is California versus Bakke, 1978, in which the Supreme Court allowed to a limited extent affirmative action policies for admission, college admission in general, and also admission to such things as law schools and medical schools. All right, those are the highlights, I think, of what we have in lecture notes 13 through 27, class notes for 13 through 27. That is the material for your final exam, along with some items from quizzes 5, 6, 7, and 8 that may be repeated. So we'll chat about that for 45 minutes at 7:45 Tuesday evening. Then you will have Wednesday, Thursday, and Friday to take the exam, 52 false and multiple choice items. Please, 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 everybody be aware, everyone is required on the syllabus to turn a paper in, and I need to have that by Saturday if at all possible. All right, that's quite a bit longer than we're generally going with some of these messages, but I felt we needed a little bit of review before the final exam. We will chat before the final Tuesday evening at 7:45. And so with that, I will wish you good luck. Please feel free to communicate with me by email about any of this, especially the term papers, david.cole@opsu.edu. So good luck on your final. Please get your term papers in, and we will see you in the chat room Tuesday night at 7:45 for any of you who would like to chat. Take it easy.